Ladies and gentlemen, first of all, thank you very much for that very kind presentation. Of course, the legal presentation will to some extent be a follow-up to what we discussed already, and maybe to some extent have a specific twist, which is of course due to the very fact that we now focus on the question of solidarity from a rather normative angle. The narrative, ladies and gentlemen, of an ever-deepening integration in an ever-closer union, expressed for quite a long time, the European polity's integrationist creed, and was shared by many Euro-optimist union citizens. However, this does not seem to be the case anymore. Along with the recent crisis-driven Eurosceptic challenges to this narrative, the fundamental principles and values it is based upon have also come under scrutiny, if not called into question altogether. In particular, solidarity is at stake. For example, when the financial crisis divides rescue policy supporters from Brexit advocates, or when the refugee crisis provokes strong tendencies, we just heard it, of renationalization in sovereignty-centered splendid isolation. Is the willingness or reluctance towards burden sharing the litmus test for European integration in times of solidarity crisis? Given that solidarity itself is both a contentious and a contested idea, the conflicts might reach even further and delve even deeper. With these uncertainties, ambiguities, and complexities in mind, the numerous references to solidarity in the Lisbon Treaty can leave a lawyer feeling somewhat uneasy. This raises the fundamental question which overall expectations, moral obligations, political assumptions, or normative force can be attributed to what the Union's primary law terms solidarity. The concept of solidarity, and I think we learned that already today, is rather young, even though it dates back to the French Revolution's programmatic leitmotif liberté, égalité, fraternité, and was already enshrined in the 1804 Code Civil. It was the French sociologist Émile Durkheim who provided the first comprehensive scientific elaboration. Many other scholars followed suit. In modern sociology, Talcott Parsons; in the field of law in general, Léon Duguay; in the field of public international law, Georges Sell. These academics not only try to translate, if you so want, the all too often neglected revolutionary ideal of fraternity into modern-day language, but also focused on conceptualizing solidarity as a mode of organizing a polity, and where such a polity transcends the nation-state, as a mode of fostering transnational cooperation. Conceived in these terms, solidarity reaches far beyond the particular moral obligations that bind an individual to the other members of his or her polity in times of need or emergency. And yet, this should not lead us to underestimate the prevailing tendency to restrict solidarity either to the private sphere, the family, friends, etc., to smaller political entities such as the neighborhood or municipalities, or to the national Schicksalsgemeinschaft. If the refugee crisis has taught us that belonging has a strong emotional impact on solidarity, it has also shown that many, unfortunately, would disagree with the description of the European demos as a people composed of others, as once suggested by Joseph Weiler. Does solidarity then nevertheless have the potential to be or to become a new constitutional paradigm for the European Union, as recently asked by Malcolm Ross in a very impressive edition, I think, with Oxford University Press. Constitutional law and constitutional theory have established somewhat of a tradition in conceiving solidarity as a program and/or a principle, and thereby paved the way for shifting the solidarity paradigm from the domestic onto the global plane. Despite this transnational development of ideas and ideals, Kirsten Schmalenbach, Sonja Puncher-Rickmann, and Doris Wydra rightly note in a recent research proposal for the Salzburg Center for European Union Studies that the notion of solidarity, so lavishly used in the Lisbon Treaty, remains ambiguous in its content. Solidarity, as already discussed today, can simply be a moral orientation of pre-legal nature or amount to a legal duty. It can be used in a purely descriptive or in a decisively normative way. Going even further, it can programmatically and purposefully be used as a means of policy making, of constitution building, and of social engineering. Different concepts of society might go hand in hand with different notions of solidarity. For example, the Christian ideal of charity, or in the Islamic world, the principle of zakat, both require the donation of a fair share of one's wealth to the poor and the needy. As already stated, solidarity's predecessor, fraternité, was conceived as a political, a philosophical, and a legal concept in post-revolutionary France and beyond. In the age of constitutionalism, many other European legal and political ideas as well as ideals have followed the French example, and public international law stepped in later, but it did so with determination. In his influential studies on solidarity, Kay Wallens refers to the conceptual evolution of solidarity in public international law as it was laid down some 40 years earlier by Michel Virari. Solidarity was first a simple notion, then a political, and finally a legal principle in public international law. The principle, having, as Anne Peters puts it, a very strong ethical underpinning, is undoubtedly value-driven. This, however, is true for many, if not all, legal principles. Human dignity first and foremost, and does therefore not preclude legal binding quality in itself. Another feature which solidarity shares with many other principles of public international law is its multifunctionality and its multi-layered character. What does that mean? There is no essential definition that can be given. We heard today already solidarity has to be put together by, bits and bytes. No essential interpretation, no essential definition can be given, but solidarity always demands a context-sensitive interpretation. Malcolm Ross convincingly therefore argues that solidarity has a persistent but a quite diverse presence in EU law. Solidarity here is perceived as a prerequisite for integration. It is contextualized with democracy, with subsidiarity, we discussed about that already, with loyalty, with sustainability, and with citizenship, the idea of cosmopolitan solidarity, for instance. None of these concepts would work without a certain degree of solidarity. They simply presuppose. In the context of human rights, solidarity is concretized as a social right to something. It is interpreted as a means of reconciling competition-based market integration and social welfare orientation. More generally, when considering solidarity as a legal principle, we must distinguish between a negative and a positive component. Negative solidarity is seen as a mere response to certain dangers or events. Positive solidarity creates, consequent upon the aforementioned previous negative notion, joint rights and obligations. Solidarity operates as a principle to achieve common goals. Sometimes it imposes common but differentiated obligations or responsibilities. It encompasses procedural and operational, substantial and normative elements, values and legal obligations, respectively entitlements. So let us have a quick look at the legal substantiations of solidarity within the European Union and also a bit beyond the European Union. What I stated so far, in my opinion, becomes very clear when focusing on the law of the EU as a form of regional public international law with specific constitutional quality, and I already apologize, now I have to cite and quote some articles, which sometimes is a bit of boring endeavor, especially for the non-lawyers. Sometimes it's also a boring endeavor for the lawyers, but since we have to start with positive law, at least in our interpretation, I think that needs to be done. Article 2 of the Treaty on the European Union, addressing the Union's basic values, which we spoke about just a couple of minutes ago, declares that these values derive from a society upholding, among others, the principle of solidarity. Besides plain economic interdependence, a political community needs a more sophisticated conception of the common good, which not only reflects the different national nations of their common good, but also has a clear focus on a common European good. Bonum commune Europaeum. Beyond this, the ideal of bonum commune might even require, and we already spoke about that too, a Kantian notion and a Kantian focus on humankind as such, in today's globalized world more so than ever before. Consequently, Article 3 TEU ranks solidarity among the Union's aims and purposes, promoting cooperative solidarity both among the member states and in the global realm, para 3 and para 5. In the intergovernmental field of the common foreign and security policy, mutual political solidarity is a prerequisite for being capable of acting at all. See, for instance, Article 24, Section 2, and Section 3 of the TEU. Unsurprisingly, solidarity and loyalty are often stem from the same spirit, as Article 24, Section 3 refers to a spirit of loyalty and mutual solidarity, re-emphasized when it comes to the voting procedure, Article 31, Treaty of the European Union. In a field where unanimous decision-making is required, the risk of obstruction by member states refraining from a vote would otherwise be too high. This is also a very interesting dimension of solidarity in the procedural infrastructure of an international, respectively supranational organization. The mutual defense clause enshrined in Article 42, Section 7 TEU, like the collective self-defense option in Article 51 of the United Nations Charter, can also be seen as an expression of solidarity, mutual aid and assistance, but is of course much more narrowly formulated. In a broader sense, all policies in the area of freedom, security, and justice are based upon the principle of solidarity, which thus becomes a constitutional element within the European Union's cooperative architecture, for instance, Article 67, Section 2, or Article 80 of the Treaty on the Functioning of the European Union. Economic integration in general, and not just the monetary union, also requires solidarity when grave difficulties arise, and not only in times of crisis. The famous Article 122 of the Treaty on the Functioning of the European Union, also Article 143 of the same treaty. A spirit of solidarity is present in the field of energy policies as well. Most obviously, terrorist attacks and natural or man-made disasters require solidarity, as is made explicit in Title 7, Article 222, through the phrase of a solidarity clause used already as headline. When Article 196, Section 1 of the Treaty on the Functioning of the European Union obliges the Union to, I quote, encourage cooperation between member states in order to improve the effectiveness of systems for preventing and protecting against natural or man-made disasters, it implicitly presupposes a spirit of solidarity between the cooperating entities. In this regard, the aforementioned Article 222, Section 1 is more outspoken, stating that the Union and its member states act jointly in a spirit of solidarity. The wording discloses the supranational intent of the solidarity clause, clearly going beyond merely intergovernmental obligations. The Union's legal architecture corresponds with this supranational intent. It displays a multi-layered structure of overlapping constitutional regimes, very often referred to as multi-level constitutionalism or constitutional pluralism. This multi-layered structure sees human relationships as well as ordering mechanisms necessary for human relationships to exist in freedom, peace, and security, no longer dependent on just one legal system, but on a mixed texture of multiple legal orders. This order structure has to take into account that different and differentiated sets of norms exists on the subnational, the national, and the regional plane, with the overarching system of public international law and other possibly relevant transnational regimes. In parallel, EU law has a very strong effect on domestic regulation and in decentralized political systems on all subnational levels as well. From all these observations, it becomes quite clear that EU memberships implies, I quote, reciprocal intrusiveness, which might at the end of the day cause a powerful sense of solidarity, a sense, however, of multi-level solidarity. In European Union law as well as in public international law, finding out the relevant meaning and normative relevance of solidarity might become at least easier if one focuses on the nexus between solidarity and other paradigmatic or even constitutional principles within the relevant legal orders. One example that holds true in particular for the law of international and supranational organizations, respectively, might be the following. Loyalty has to be clearly distinguished from solidarity, agreed, but loyalty without a minimum degree of solidarity would be theoretically inconceivable and practically impossible. even though inseparably intertwined, are solidarity and legitimacy. The successful integration of any polity, national, regional, or global, depends on what Joseph Weiler, in his famous essay on the transformation of Europe, calls social legitimacy. I quote, "What becomes crucial for the integration process is the social legitimacy of the new integrated polity, despite the loss of total control over the integrated policy areas by each polity." I think this kind of identity also is something we discussed today, and solidarity could be the glue for this identity, but it could also, and this is, the paradox we have to deal with, could be very detrimental for this identity. Another nexus or systematic context is quite obvious. Solidarity has a human rights basis, not only with reference to the already mentioned solidarity rights, but also when focusing on a responsibility to protect. In this regard, the European Union, wanting to promote human rights, democracy, and the rule of law, is in external policies, can learn from the international community. United Nations General Assembly Resolution 193 on the promotion of a democratic and equitable international order states under number 4, lettera F, I quote again, "Solidarity as a fundamental value by virtue of which global challenges must be managed in a way that distributes costs and burdens fairly in accordance with basic principles of equity and social justice, and ensures that those who suffer or benefit the least receive help from those who benefit the most." The declaration expressively contextualizes solidarity with equity and social justice. This is something we are, I think, quite familiar with in Germany, given the social market economy and our social security systems. Last but not least, solidarity can be seen as a way of rationalizing collective responses towards a range of new threats, and of old threats too. As already stated, the maintenance of peace and security provides most likely the most striking example. The way European Union law uses solidarity qualifies the concept as a constitutional paradigm. However, that does not mean that this constitutional paradigm has a very clear, unambiguous, or predefined meaning. In the context of citizenship and loyalty, it frames duties of membership. In the context of human rights, it displays universal tendencies. In its most extensive and most idealistic reading, solidarity addresses the needs and aspirations of humankind as such, the cosmopolitan dimension, and requires a humanization of international law in general. Again, a quote this time from Jenks, who wrote a very famous treatise on the common law of mankind. In a more limited, that is to say in an integration-oriented reading, solidarity is both a prerequisite for and a means of integration. Solidarity, however, is by no means a European deus ex machina, but it is much more than altruistic semantics about economic redistribution. As shown, solidarity has found manifold legal substantiations in EU primary law, which can be relied on in court proceedings. Solidarity in that regard can be enforced. As a constitutional paradigm conscripted for the establishment of a politically stable and integrated order, solidarity is in fact grounded in fairly selfish motives As the great European Jacques Delors said, I quote, "Solidarity mechanisms are not based on pure generosity, but on enlightened self-interests. Whenever we today hear the voices of irresponsible populists trying to destroy the European project, we then must never forget that we live in and have to fight for an age of enlightenment." Thank you.